Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. Today we have a special guest with us, Rania Arwani with the Arwani Law Firm. So I love, Rania, what you say here. You are a mother, a wife, a family law attorney, business owner, women's rights advocate, and philanthropist. So I love it that you're a mother first. That's great. You got your bachelor's, or she got her bachelor's in finance in Texas. She attended Barry University School of Law. She was a research assistant at Barry University School of Law and a certified legal intern for the Children and Families Clinic. She's trained with the Florida Center for Child Welfare. She's very involved in the fight against domestic violence. Welcome aboard, Rania.
Oh my God, thank you. What an introduction, Tom. Thank you.
You've done a lot. That's only a small fraction of your bio, so
Thank
it's a
you.
lot. So let's talk, okay? This is a Healthy Family Law Attorney, and because I believe families matter, we want to provide hope and help to families to successfully navigate the family law process in a healthy way. I know you are in alignment with that. You want to do things to help your clients, to provide hope to them. And so one of the things we're going to talk today about is misconceptions clients may have about the family law process. And so that first misconception is that a bulldog attorney is going to be the best attorney for them. Why is that a misconception?
Well, from my point of view, to begin with, it's a very costly process. Going to court, going to trial is extremely expensive. So a bulldog attorney who is not going to compromise, which means you're not going to reach a settlement, which means you're going to end up going to court, with paying a lot of money, attorney fees, what have you. Maybe the parties are going to need financial experts. It gets extremely expensive when you have a bulldog attorney who is not willing to compromise. Because the way I see it, a bulldog attorney is not going to compromise.
Very true, very true. And I'm going to say too that judges really know the attorneys. They come in, we come in before the judges all the time. You gain a reputation with the judge. So if you're like just one of these bulldog attorneys that are just always arguing, regardless whether it's a valid argument or a good case or not, there's a saying that I've heard judges say. So if you have the law on your facts, you pound the law. If you have the if you have the law on your side, you pound the law. If you have the facts on your side, you pound the facts. And if you have neither, you pound the table. So that's what sometimes those attorneys do. So it's not necessarily the best way to go about it, right? With a bulldog attorney, it may air your dirty laundry more than you want and things like that.
And then think of it this way: when you air your dirty laundry, husband hates wife, mother hates dad hates, the parties will hate each other. And there is no way that this animosity and the dislike and hatred toward each other is not going to affect the children. It will. No matter what they do, the kids will feel it. So it affects the family as a whole, let alone, as we said, they end up with less money in their pockets, which is, in my opinion, there are ways to settle all issues. Some issues maybe not, but most issues should be settled.
Yeah, I couldn't agree more. Okay, let's talk about maybe misconception number 2, that the court's going to have a presumption that the starting point is a 50-50 split of time sharing or custody in every family law case. True or false?
True. I'm kidding. False. False.
Okay.
No, I'm kidding. I'm kidding. No, we follow what we call the best interest standard. There are factors A to T, and the court must go through these factors, and it is not 50-50. The court, the way mom and dad will start at equal footing, unless there is a reason, someone is negligent, there is domestic violence, whatever those factors, if they don't align with that parent, then it will affect the turnout of the custody, or the time sharing schedule, parenting plan, what have you. So yeah, it's not 50-50, but I believe they start at an equal footing.
Right. Yeah. I think some judges may secretly kind of think 50-50 is a starting point. They would never say that because that's not what the actual law is. And as you and I know, the legislature actually passed a statute or a bill, I should say, that made 50-50 the presumptive time sharing starting point. But the governor back then, Governor Scott, vetoed that. So the law is, as you said, Florida statute 61.13 sub 3, A through T are the 20 factors that the court has to consider in determining what the time sharing arrangement is going to be, right?
Definitely. Weren't you scared when that bill went, and weren't you so happy that the governor struck it down, that bill? I was so terrified.
Yeah, I mean,
50-50 presumption, I think it's an awful.
Yeah, so that's clear now. That's not the presumption under the law in Florida. Okay, our third and final misconception. Clients sometimes think that they're going to be able to walk into court and just tell their story without any interruptions, without any, restrictions, and that the judge is going to hear their story, see it their way, and rule in their favor. What do you think?
No, I would be nice. No, not going to happen.
Right.
We have our rules of evidence. We have limited time to start with. You get, if it's you sometimes get a full day hearing or a full day trial. That means half a day for, mom, half a day for dad, husband, wife, whichever. And you have to kind of put on the evidence for the children, for the asset and the liabilities. I mean, you only have so much time. You put the client and have the client kind of try to tell their story. First of all, it's wasting the time, and the judge will immediately think, how is this relevant to the case? Is this going to make me change my mind if you tell me your story? Get to the point. Let's just, see what we need to, rule on. So they cannot. It's very difficult. And like I said, when it comes to evidence, that you can stop whoever's on the stand from, hearsay, bringing evidence that actually cannot come in as evidence or a document or what have you. So yeah, right. The story is extremely difficult.
Right, absolutely. I think that's so true. I mean, it's hard to ever get as much time with the court as you'd like, because you go to these pre-trial conferences and the judge says, well, that's all the time I have. And so you got to fit your case into that. And then you got to be constrained by the rules of evidence. And then the judge is supposed to make some great wise decision like Solomon. So it's a really difficult situation. Litigation is hard. That's why both Rania and I practice collaborative law, and the parties get to be so much more involved in the process, and you don't have anybody rushing you, and your goals are set out there, and you can work it out collaboratively, right?
Definitely. I think that is the way to go.
Yeah. So, okay, what is the best way in your mind to approach a family law case?
From my perspective, I think, when husband or wife walks into your office, I want to get a divorce, I think the first thing an attorney should do is see or explore, is there anything this attorney can do to help the couple get back together, if there is a chance to fix the relationship, especially if there are kids. And that is something that I explore or, discuss with the clients quite a bit, and see if there is a chance. Then definitely they have to kind of, try to get back together, especially, like I said, if there are children. What do you think, Tom? What are your thoughts on that issue?
Well, one of the things I like is something I learned in Stephen Covey's book, 7 Habits of Highly Effective People. And that is to seek first to understand and then to be understood. And so, we're highly trained, experienced lawyers. A lot of lawyers want to just start telling the client what they think should happen in the case. But I think we should listen to the client first, seek first, understand what the client wants to try to accomplish. It may be completely different than what you were thinking. So I like to really listen to the client first.
And get their goals. What are your goals in this? The solution. What are something you are willing to compromise on, and what issues are you absolutely not willing to compromise on? And then if you have a discussion with the client and figure out if it's an issue that should be compromised on, then at that point, you should have we have discussions with the client, explain to them, good decision, bad decision, what have you.
And of course, like you, I want to explore the possibility of reconciliation because, well, you and I know that it may be about 50% of first marriages end in divorce, but it's 62 or 3% of second marriages. It's in the mid 70s of third marriages, and it's like 90% of fourth marriages end in divorce. So it's not that it's greener on the other side of the hill. So if the parties are willing to do something different, change, not avoid Einstein's theory of insanity, doing the same thing over and over again, expecting a different result. If they want to do it differently and reconcile and not be put back into a situation of where there's domestic violence or something, we don't want that. Mm-hmm. But if it's safe and they're willing to make work on it, both sides, and make those changes, yeah, that's great too.
Yeah. We have amazing, mental health counselors. They can go to counseling, marriage counselor, to help them, see if they can fix the issue, if there is something to be fixed.
Right. So, okay, let's circle back to collaborative. What do you think are the primary benefits of collaborative over a litigation case in family law?
The first thing is, the stranger in the black robe is not making that decision for you. You are coming to a decision with your partner on how this divorce, how you're gonna, divide your assets, how this parenting plan is gonna look like. You're not showing up and a stranger with limited time making a decision that's gonna affect you for the rest of your life, or until your kids are adults or what have you.
Absolutely.
What do you think?
Yeah, and I think that if the parties, husband and wife, the couple, come to reach a decision themselves, in a collaborative way together, they're much more likely to both commit to that, adhere to it, and stay with that decision. Sometimes if a judge or somebody imposes a decision on them, they're going to do everything they can to fight against it and maybe be back in court, unfortunately, or something like that. So that's another benefit. They reach the decision in a collaborative way. Okay. What are, nothing's perfect. Nope. So collaborative is not perfect. What are some of the objections you've heard to collaborative?
The main one where it really kind of turns the clients or potential people who are going through a divorce or thinking about it is the fact that they lose their attorney. That is one thing that shuts down the whole thing in front of them. And to me, yes, it's not a great thing, but it is a reason to maybe encourage the other party to settle, to reach an agreement, because at that point you're kind of losing your attorney, the person you trust. You have to find someone else, and you're starting from zero. Not only did you waste time and money, now you have to find another attorney to go through the traditional process. So right. I think even though it's a hard pill to swallow, I think it will encourage both parties to think hard before they exit the process.
Right, and the reason for that is the rules around collaborative are that if the collaborative case does fail, which is rare, honestly, the attorneys cannot continue on to the litigation case. And the reasoning behind that is so that no attorney doesn't benefit from the collaborative failing. They're fully invested in getting it done and helping the parties resolve it. Another objection I hear sometimes is, well, it's expensive because you've got, the two attorneys, but then you also add in the two neutrals. You have a mental health neutral and a financial neutral. The reality is, if you and your spouse can resolve it without any litigation and go straight into maybe a mediation and get it done in a one-time mediation, that would be less. But collaborative is far less than a full-blown litigation case. Don't you agree?
Oh, 100%. And think of it this way, it's a team. You are a team a team of professionals are working with the parties to help them get to a place where both of them are happy. Even in mediation, you're still, opposing counsel and counsel, petitioner and respondent. In the collaborative process, we're not that. You're not opposing counsel. We are a team. You are Tom. I am Rania. It's a really easy process, and it's not that contentious. So it just, even though it's like you said, even though that the attorney they have to leave, but the process itself, I think, will eventually help the parties reach an agreement.
Right, and it's done in such a more healthy way than in the litigation process. And of course, this is the healthy family law attorney. And so I always ask my guest, do you have a healthy tip for our viewers today?
Meditation.
Meditation, okay.
It was difficult to get into because, as an attorney, Tom, your brain never stops. You're just thinking emotions, whatever, so many things. It took a while for me to kind of slow down and just enjoy the silence.
Very true. Very true. And meditation, can take on different forms, like me working in the yard and just being out in nature and having time to reflect and to meditate, or it could be meditation on scripture, whatever is, best for you. I totally agree. So, I want to thank you, Rania, for being on the channel today. If our viewers have enjoyed this, I would love it if you would subscribe to the channel, hit that like button, hit that bell icon, leave a comment if you really enjoyed hearing from Rania, or if you would like to hear us talk about another topic or anything that we've said today that raised any questions for you, let us know. And Rania, thank you again for being on the channel.
Thank you so much for inviting me, Tom.
Okay, and we will see our viewers next time. Thanks so much. Bye-bye.